She stood in front of my house, pointed at my father's wheelchair ramp, and said it was lowering property values. 3 weeks later, she wasn't the HOA president anymore. She showed up on a Tuesday afternoon, right as the contractor was tightening the final bolts on the wheelchair ramp. No call, no email, just the sharp click of heels on concrete and that familiar HOA clipboard tucked under her arm like a badge of authority. I stepped outside to greet her, thinking maybe she had a question about the permit or wanted reassurance that everything was approved. Instead, she stood at the bottom of the ramp, tilted her head, and let out a slow, exaggerated sigh. "That thing," she said loudly enough for the neighbors across the street to hear, "is an eyesore." The contractor froze. My father, who was sitting just inside the doorway in his wheelchair, heard every word. She didn't lower her voice. She didn't even pretend to be concerned. She walked up the ramp slowly, tapping her pen against the railing as if inspecting a crime scene. "This isn't the kind of structure we allow in this community," she continued. "It looks temporary, cheap. It brings down property values." I reminded her calmly that we had city permits, that the design met all regulations, that it was installed for medical necessity after my father's surgery. She smiled, not kindly, but tightly, and said, "Medical issues are unfortunate, but they don't override community standards." By then, 2 neighbors had stepped outside. One pretended to check their mail. Another just watched. She turned toward them and gestured at the ramp like she was unveiling a scandal. "This is what happens when people ignore architectural harmony," she announced. "Ignore. As if we snuck it in overnight." She scribbled something on her clipboard, tore off a slip, and handed it to me. "Expect a formal notice," she said, already walking away. That was the moment I realized this wasn't about wood and railings. It was about power. The fine arrived 3 days later in a thick white envelope stamped with the HOA seal, like it was something official and untouchable. Inside was a formal violation notice demanding immediate removal of the ramp and a $500 penalty for unauthorized structural modification. The words were bold, cold, and carefully worded to sound final. 7 days to comply. No exceptions. I reread it twice, then a third time, making sure I wasn't missing something. We had submitted the architectural request form. We had attached the city permit. We had included a letter from my father's physician confirming medical necessity. Everything had been sent weeks before installation. Yet the letter claimed no request had ever been approved. It ended with a warning. Continued noncompliance would result in escalating fines and potential legal action by the association. That evening, I learned there had been a special board session. No community-wide notice. No open discussion. Just a closed-door meeting labeled Aesthetic Review. A neighbor quietly texted me that the ramp had been projected onto a screen and debated like a zoning dispute. According to her, the president had described it as permanent damage to the community's visual identity. Someone asked whether disability accommodations had protections. She reportedly waved it off, saying, "We don't make exceptions. If we allow this, where does it end?" The message was clear. This wasn't about paperwork anymore. The following morning, a second letter was taped directly to the ramp railing for everyone walking by to see. It listed the deadline again in bold red ink. The humiliation felt deliberate, almost theatrical. Neighbors slowed their cars as they passed. Curtains shifted across the street. 7 days. That was all the time they thought we needed to surrender. I responded the same day the second notice appeared. I attached every document again. The city permit stamped and signed. The contractor's license. The physician's letter confirming long-term mobility impairment. And the original architectural request submission with timestamp proof. My email was direct and calm. I asked one simple question. On what legal basis was the association denying a disability accommodation? Her reply came hours later. Shorter than I expected. The board retains authority over exterior modifications to preserve community standards. Nothing about the Fair Housing Act. Nothing about medical necessity. Nothing about federal protection. Just community standards. That was the moment I realized this had moved beyond neighborhood politics. The next morning, I called a disability rights attorney. I explained everything: the inspection comments, the public humiliation, the fines, the posted notices. There was a long pause on the other end of the line. Then he asked, "Did they put the removal demand in writing?" "Yes," I said. "Good." Within a week, a certified letter was sent to the HOA board and its legal counsel. It cited federal fair housing protections requiring reasonable accommodation for disability-related modifications. It outlined the timeline of events and referenced the public comments made at the meeting. It formally demanded the immediate withdrawal of all fines and written confirmation that the ramp would remain without penalty. The letter didn't threaten. It didn't rant. It simply stated that continued interference could constitute discrimination under federal law. 3 days passed. No new violation notices. No emails. No taped warnings. For the first time since this began, the board went completely silent. And silence, in that neighborhood, was never normal. The shift happened quietly at first. The red violation notice taped to the railing disappeared overnight. No explanation. No acknowledgement. Just gone. When I logged into the HOA resident portal later that morning, the $500 fine that had been sitting under outstanding balance was no longer there. It didn't show as paid. It didn't show as waived. It simply vanished, like it had never existed. By noon, an email was sent to the entire neighborhood. The subject line read, "Clarification regarding exterior modifications." It was carefully worded, almost sterile. The board stated that it fully supports accessibility accommodations consistent with applicable law, and that any prior communications may have reflected procedural misunderstandings. Procedural misunderstandings. That was how they reframed public humiliation and a removal deadline. But something else had changed. The tone wasn't confident anymore. It was cautious. Later that evening, a neighbor forwarded me a screenshot from a private HOA group chat. Someone had mentioned that the association's insurance carrier had been notified after receiving a copy of the attorney's letter. Apparently, discrimination claims weren't minor matters. Coverage reviews had been triggered. Legal exposure was discussed in phrases like substantial liability risk. 2 days later, an emergency board meeting was announced. This time properly posted. The agenda included legal compliance review and mandatory board training. The president didn't speak much during that meeting. When questions arose about accessibility law, she deferred to the association's attorney, who attended via video call and emphasized adherence to federal protections moving forward. For weeks, she had been decisive, loud, unwavering. Now, she was careful, measured, and noticeably quiet. The resignation email arrived at 6:42 a.m. on a Monday. Short, polite, vague. Due to personal reasons, I am stepping down as HOA president effective immediately. No mention of the ramp. No reference to the attorney's letter. No acknowledgement of the emergency meetings or the compliance review. Just a quiet exit after weeks of noise. By midday, the neighborhood was buzzing. Another email followed from the remaining board members announcing an interim president and reaffirming their commitment to inclusivity and lawful governance. The language was noticeably different from the earlier violation notices, where there had once been bold deadlines and warnings of enforcement. There were now phrases like community harmony through understanding and respect for accessibility needs. Later that week, something else surfaced. A neighbor who had attended the closed-door session shared that internal emails had circulated among board members before the fines were issued. In those messages, the ramp had been described as setting a precedent we don't want and opening the door to more requests. The tone wasn't about safety or compliance. It was about control. Once those messages were reviewed by legal counsel, the situation had shifted from aesthetic disagreement to potential discrimination exposure. The scheduled special vote to review board leadership never happened. It didn't need to. The ramp remained exactly where it was. solid and steady against the front of the house. No more notices. No more stickers. No more fines appearing in the portal. Neighbors who once avoided eye contact began stopping by again, some offering quiet apologies for staying silent. The power struggle that began with a clipboard and a comment about property values ended with a resignation and a rewritten policy. The ramp stayed. The president didn't. If you enjoy real HOA drama with satisfying twists, hit subscribe. You don't want to miss what happens next.